Welcome back. Missed seeing you guys. It's good to spend a little time with you, even though it's virtual. Today we're going to launch our ship of class into the realm of the judicial branch. So, as I'm sure that you guys have seen on Schoology, you've had an assignment yesterday, and we'll go ahead and look at what you have coming the rest of the week. So yesterday was the 4th, and you had a case brief. Today we're going to do some notes about the difference between criminal cases and civil cases. These are two different types of cases that our courts hear. Tomorrow, as I told you on Monday, there's a lot of case briefs. So you have another case brief on Tinker versus Des Moines. And then we'll do some notes on Thursday, and Friday you're going to have another case brief, McDonald v. Chicago, which is a newer case. So hopefully you guys are keeping all your case briefs in a central location, as they will be a very helpful review tool whenever it comes time to take your AP test. So and this particular unit on the judicial branch is pretty important when it comes to the information you're going to need for that test as well, as they all are. So let's go ahead and get started for today, and we'll get the PowerPoint up. So this, like I said, this unit is all on the judicial branch, and you all have already done your vocabulary words, and there were 17 for this particular unit. We looked at some things like, you should already know several of them. Marbury versus Madison. That's basically just the court case that established judicial review. You need to know the difference between a civil case and a criminal case, and we're going to discuss that today. We'll talk about what an arraignment is, and the different types of bail, whether it be surety or property bonds. Felonies, the difference between felonies and misdemeanors. We'll talk about how our nation uses the dual court system. We'll talk about some of the things that police officers and law enforcement officials have to have in order to make an arrest. The difference between juveniles and adults and how they're tried differently within our court system. Plaintiffs and defendants, and we'll talk about that today actually when we get into the civil cases. There's a couple amendments that are very important when it comes to the judicial branch as to how they interact between the state and the federal government. Magistrate and other different levels of judges, which a magistrate is simply just the lowest form of a judge. Different types of jurisdiction that cases can have, whether it be original or appellate. And then judicial review, which was actually established by the court case Marbury versus Madison, which simply allows the Supreme Court to declare a law or an executive order unconstitutional. All right, so those are your vocabulary words. All you had to do is simply write them down. But to get going today, let's start with the different types of courts. And today we're going to do criminal. All right, the first one we're going to do is criminal. So these are the procedures that if you are arrested, you are going to want to be aware of. So I'm pretty sure that none of you will probably ever have to worry about being arrested. However, that is not the case for much of America. As if you look at the numbers, a significant portion of Americans are arrested at some point in their life. So I'm not saying it's going to happen to you, but if it does, it's good to know these procedures, okay? Because if you find yourself in a criminal court, these procedures will be good to know. All right, so the entire purpose of having these criminal procedures is to determine if a crime has even been committed. So we're not living in medieval feudal Europe, where if you say something inappropriate or against the king, he could just lock you up for an indefinite amount of time with no trial, no jury, no lawyer, and have you tortured every day. That's not how it works in America. We have these procedures for a reason. So the court's going to try to determine if a crime has been committed. All right. So first off, in order for you to be accused of a crime, you have to be arrested. And before you can be arrested, there has to be evidence that links you to this crime. They cannot arrest you without having some sort of evidence. And that evidence has to be presented in a way before the police officers, before the judge. A judge can give you permission. Now, if probable cause has been established, then yes, you can be arrested. If there is no probable cause, you can get permission from a judge, which is a warrant, who's going to want to see probable cause, who's going to want evidence to not necessarily prove your innocence or guilt, but to prove that there is a likelihood that a crime has been committed. Okay, so that's the first step. Okay, so you're going to be arrested by the police. So once you're arrested by the police, you're going to do whatever kind of booking procedures that particular law enforcement entity has, whether it be fingerprinting, DNA testing. It all depends upon what those officers and that station's protocols are. But then you're going to have what's called an arraignment. Now, a lot of things happen at an arraignment. Okay, first thing is the judge is going to review the probable cause, that there is probable cause, that the police had good reason to arrest you, that it was done fairly, that it was not a bunch of fake charges. Okay, the judge reviews probable cause, make sure that the arrest was done legally. All right, so once if the judge says yes, the probable cause has been established, then it'll continue on. If not, the arraignment can simply throw your case out. So once the judge says, okay, yes, probable cause has been established, then the judge is going to do several things. They're going to ask you how you plead. Are you guilty or not guilty? Or you can plead no contest, a variety of different ways. But usually you're going to plead guilty or not guilty. I was in a motorcycle accident in Virginia, and I lost control of the motorcycle, and I wrecked, and I was cited. I messed myself up really bad. I broke my leg terribly, but I had to go to court because I failed to maintain control of the vehicle. And I went through all this. Now, I wasn't arrested or anything, but I had to go to traffic court. And the judge says you've been charged with failure to maintain control of the vehicle. And I was like, they asked me how I plead. I said guilty. And I was sitting in a wheelchair there. It was pretty obvious. So and they actually lessened my sentence, or lessened the crime. Not that it was a crime, but they actually said I can't even remember, but they lessened it, and just because I pled guilty. Anyway, in more serious crimes, at your arraignment, they'll set your court date, tell you when you have to appear. That's your court date, and then depending upon the severity of your crime, they may set a bail or bond. And the more serious the crime, the higher the bail is going to be. Could be $3 million, could be $5,000. It's all dependent upon that judge, and it's all dependent upon what crime that you committed. And we'll talk about how you pay those bail and bond and how that works. The entire purpose of bail and bond is not a money-making scheme by the judicial branch. It's to ensure that you show up for your trial. That's the whole purpose. That's what they want. So if you are deemed to be dangerous or a flight risk, or you have the means to leave, you may be remanded, which means you may have to stay in a jail until your trial is conducted. You should already have an attorney at your arraignment, especially if you've committed a serious crime. If you cannot afford to have an attorney, the government will give you one, and they will represent you and your interests. But just be wary that you get what you pay for. Okay, so you're given an attorney who probably has 50 other cases they're working on at the same time, whereas if you bought an attorney on your own, it may have 1 or 2 or 3 cases. So just you get what you pay for. That being said, attorneys are extremely expensive. All right, so there's a lot of moving parts, a lot of things going on at your arraignment. All right, so whether you're released or remanded, whatever happens, you show up for your trial date, and your trial is conducted. Okay, and a couple things can happen as a result of that. You can be found not guilty, or you can be found guilty. If you are found not guilty, you're free to go. Okay, you are acquitted. I guess this, whatever the charges are dropped, whatever happens, or you could be found guilty. And if you're found guilty, you can simply accept your sentencing, or you can appeal to a higher court to determine the fairness of the original trial. Now, if you just want to try to get another court case just because you don't want to go to prison, that is not how appeals work. In an appeals, when you appeal your original sentence or you appeal your original case, you are saying that your trial was not fair. That is the only real thing. You can't appeal just because you were found guilty. All right. The only thing you can appeal is the fairness of your original trial. All right, so I don't want you to think that just because I'm guilty I can appeal. People do that, but it's not that they're appealing the decision. They're appealing the treatment or the fairness of the trial. Okay. All right. So hopefully you guys never have to experience these serious criminal procedures firsthand, but if you do, that's kind of what you should be expecting. All right. All right. So that's criminal procedures. Now let's take a look at the civil procedures. Now you got the picture there, Judge Judy. You probably all know Judge Judy or Judge Wapner, or Judge Joe Brown. Those are all civil type of cases that you see. Now the purpose of a civil case is to settle a dispute between two or more parties. Okay, so it's not necessarily that a crime has been committed. All right, like if my neighbor parks his car in his parking lot, but the tree that I have in my yard drips sap onto his car and ruins his car's paint. That tree is not committed a crime. I have not committed a crime. However, there has been damages that has occurred, and my neighbor believes that it's my responsibility to pay for those damages. I may not agree with that, and so we would go to a civil case or a civil court to settle that dispute. All right, so the person who would file the complaint is called the plaintiff. It's super easy to remember that. Plaintiff, okay? Just kind of remember that plaint is in both of those. It's the person who's trying to recover damages or receive money or compensation in some way. It could be like I hire somebody to come and, add a room onto my house. So I hire a contractor to come add a room onto my house. They say, yeah, well, you can do this job. And so I give them, here's $15,000. I give them $15,000. And they take my money and they begin work, okay? And then, here we are, it's January 5th. They get a job to go work, to go build a brand new restaurant. They're going to get $500,000 to work on that one. And so instead of finishing my job, my room, they go work on the restaurant and leave a big gaping hole in my house in the middle of winter because they could make more money finishing, doing a larger job. So I feel like I'm being wronged, and so I could actually sue for that, okay? And I would be the plaintiff in that case, and the carpenter who abandoned my home in the middle of a job would be the defendant, okay? All right, now not all cases have to go to court. The cases can be mediated out of court by the two parties. They can simply come to an agreement without having to go before a judge. And there are actually people called mediators who try to mediate these things before they go to court. And what usually happens as a result is called a settlement. So, but if it does go to court, it will be heard by a judge. And in very, very, very rare cases, it can be heard by a jury, but it's very rare. And then just like in criminal cases, the rulings are either accepted by the victor or the loser, or they can be appealed to higher courts. and only to determine the fairness of the original trial, not to change the outcome. Okay? All right, so these are our two different types of courts. You have criminal courts to determine if crimes have been committed, and civil courts are not about crimes. They are to just settle disputes. Okay? All right, so next time we're going to talk about the dual court system in the United States and in the state of West Virginia, and how those courts work within our dual court system. So I hope you guys are doing well. I know it's been a long time since we've been at it, but it's time to get back to work. And I showed you what you got the rest of the week. Mrs. Hawkins is going to let us know about semester exams very, very soon. So anticipate having some sort of semester exam, but I'm not too concerned about it. I'll prepare you for it as best I can, and you guys will do well. All right. So if you have any questions or you need to talk to me about anything, always you can email me, send me a message on Schoology, call the school. If you want to have a face-to-face Teams meeting, we can do that. I'll arrange that. Just let me know, and I'm here to serve you guys. Okay, so I hope you guys have a good day, and take it easy.